And there's a chat function, which is important. We'll keep sharing information on the chat function. Awesome. Okay, great. So I think we're ready to roll. Welcome everyone to day 5 of ODR week. What's amazing about these first few days has been the kind of a variety of audience that we have seen. We've seen students and practitioners and entrepreneurs and business people, and it's remarkable. And we are nearing almost 5,000 views across different platforms of the conversations, and just this feeling that somehow the conversation has moved on from being a smaller circle of people, enthusiastic, no doubt, but a smaller circle to a bigger circle. Very long way to go. So I don't want, 1 week does not make a goal. But definitely a feeling that we are at a good place on day 5. We wanted to end day 5 of ODR week strong, so I'll tell you a little bit. But before that, if you're joining us for the first time, my name is Sachin, Malhan, and I work with an organization called Agami. And Agami is really focused on increasing the innovation and entrepreneurship that we are seeing in our systems of law and justice. So we do whatever it takes to create, find, and amplify more change makers in the area of law and justice. It's as simple as that. Sometimes we're accelerating something, sometimes we are celebrating innovators, bringing people together like ODR. We do what it takes to push innovation forward in a particular in the fields of law and justice. And ODR is no prizes for guessing one of the most important areas because of its potential to disrupt the pendency logjam, and also just to shift us to a much more efficient, collaborative society. So that's why ODR week. And there's been many conversations that have happened day 1 to day 4. I don't want to, there's been a lot of capture of that as well. You would have seen little videos and stuff. So I won't dwell too much on that, but fantastic conversation so far. Day 5. So the way we're looking at day 5, I just want to share a bit with you, and there'll be more information later. But day 5, we've broken day 5 into 3 pieces. One is that on day 1, there was a startup showcase that happened, which was really focused on startups whose products are ready and who are actually solving disputes as we speak. They're solving disputes using ODR. And that's one set of learnings and experience. But we also have, as an organization and a sector, we have this huge bias also for those who are almost there, those who are developing their products, who are about to get to the point where they can release something and start to solve problems. And because of this sort of bias and this recognition of the importance of even those who are at a very early stage level, or even at not very early, but almost at the product is ready level, we thought we'll create another space which we call In the Works. And today we've got about half an hour dedicated for 3 of these startups that are at that stage. So I'm looking forward to that conversation. Once we're done with that first component, we move into a section called Open House. This to me is actually really close to my heart because again and again, we've seen through the week, people raise questions around certain issues. And there is a feeling that there are these barriers to the success of ODR that all of us need to talk about. And there are these 3 issues that are perceived as barriers that we felt we should have a discussion around them. We shouldn't leave those issues as just, kind of just hanging there. And these 3 issues, that have come up again and again. One is e-signing. One is the legal framework around ODR. Do we need an additional legal framework? And the other is whether ODR should be mandated for certain kinds of disputes. So these 3 things we're going to use in the open space. We have an amazing facilitator in the form of a very well-regarded ODR professional mediator, Prathamesh Popat. He's going to facilitate a conversation, asking some experts in this group, and we have some wonderful people to provide their expertise. And we're going to end super strong. We have a group of people who represent disruptive ways of thinking and leadership across law firms and enterprises and government systems. And we have a small group that has already been active through the week. And we said, let's pull them all together and let's ask them, where do we go from here? Is it enough to just have this enthusiastic conversation, bring out the issues, articulate, how we do it, right? Sometimes we do it so well, but where do we go from here? How do we make this happen? Who else is going to make it happen if not us? And how do we make it happen? So we're going to end strong with that last component, and I'm hoping that we'll have a lot of people plugging in and being a part of that. So without further ado, I want to hand over to my colleague, Kirtana, to facilitate and call out the startup showcase. I want to mention one thing. I think it's super important. in Keep Chat, you'll see a link to something called Slido. Slido is the tool we are using for comments and questions today. So if you have questions or you have comments, you can put them in Slido. And the cool part is the rest of the crowd, including those on YouTube, can up and down vote those. So if you really like a question, you don't have to ask the same question again. You can just add it or upvote it, and it's worked fantastically the last 5 days. Either we've used Zoom's Q&A function or Slido. Both have been great. This upvoting down, this democracy thing works, I hope. So over to Kirtana. Let's get started with the first session of the day. Kirtana, kick us off.
Thank you, Sachin. First up, we have a startup from Chennai. He's not a lawyer by background and has been working on this platform for a while and very active in the space. Very excited to hear his solution and the cases that he's most excited to solve. JustAct, Prashant, go ahead.
Yeah, thanks, Kirtana, and thanks, Agami, Sachin, and Kirtana, especially for giving us this opportunity. And what I'll do is I'll kind of open the presentation. Give me a minute, then we kind of.
In the meantime, if anyone has questions for Prashant, please post them on Slido. We will have time for 1 or 2 questions in the end.
Sure. Thanks, Kirtana, again. And I'll try and make use of the 5 minutes that are given to me. What we believe at JustAct, what we believe is to offer ready, relaxed resolution.
Hi, folks. If you're not using, if you're not speaking, you'll have to mute. Please, our request is, we'll have to be super careful about our mute, unmute button. Thank you. Back to you, Prashant.
Thanks, Sachin. And so we were saying, JustAct, we believe in offering ready, relaxed resolution. And the founding team is like this: Mr. N.L. Raja, who's along with Karthik, the founder. Mr. N.L. Raja has about 3 decades of practice. He's a senior advocate at the Madras High Court, a founding trustee of the Nani Palkhiwala Arbitration Center. He's an author, has been on the Law Commission committee suggesting changes to the Arbitration Conciliation Act. Karthik, the other founder, is IMC BITS Pilani alumnus. He's on the board of KKR Financial Services India. He's also the MD of Deutsche Bank for about 15 years, was in London and came back, and now runs the Teleconnector Group, which has a couple of other companies and another startup. There's me, and there's NS Anand, who brings in a host of data science experience. He's from IIM Codicode and IIT Madras, and he's a board member at Asian India, which is a Series C funded startup. And you'll see in a minute why we've got a lot of focus on data science and technology. The way we believe the ADR funnel works is negotiation, mediation, arbitration as an escalation. And I'll explain to you in the subsequent slides how. And the way we've kind of structured all 3 pieces of the ADR solution puzzle like this. Negotiation, the way we've kind of structured it is to use an algorithmic game theory based solution so as to resolve, and what we believe about 2/3 of disputes will and get resolved in negotiation. All the disputes that can be quantified and all financial and commercial disputes, more or less, we heard Colin talk there before about that. And this is the assisted, kind of negotiation. This is the assisted, technology-assisted conciliation that we spoke. The engine is something which we're kind of creating with a lot of zeal. It's got a lot of inputs in game theory, and it learns over a period of time as we resolve disputes. It's going to become better, uses AI, and what it does to dispute resolution is it reduces costs and time of resolution immensely, and is also convenient and user-friendly for people to use at the convenience on the confines of their home at any point of time. We're providing both for synchronous and asynchronous negotiation. Quite unique, and we think quite an interesting piece, and I'll be happy to take questions on that in the 2 minutes thereafter. On mediation and arbitration, to keep it simple, and that's what Kirtana's brief said to me, keeping the diverse audience in mind and keeping the kind of time paucity, I kept it quite simple. I mean, we basically believe we are an aggregator to consolidate capacity that exists today in either institutionalized manner as mediation houses or arbitration centers, or as individuals who are neutrals in this space. The demand, I'm not going to talk about, but that's something which we all understand. There are 3 crore plus cases. So the demand and capacity consolidation happens on the platform. We work as an aggregator. We offer using parameterized ranking of all the neutrals that there are. Ensure that no additional experts are required to be called in by doing what we call a domain expertise fit, which is something which happens when you match large scale capacity with large scale demand. And specifically believe in a single set of rules rather than the dichotomous rules followed by different neutrals at different locations to give us what we feel is repeatable and sustainable.
Prashant, quick time check, 2 more minutes, okay?
Yeah, sure. I'm kind of done. Yeah, thanks. The other important piece that JustAct believes is in creating a lot of capacity, and I'll tell you why, and in building a pool of neutrals as we go along. One important trait is important stepping stone to success. It empowers the neutral to resolve disputes the way he or she would encounter more success and build credence and independence as we go along. We start with face-to-face training batches, and we've got a lot of online content that we believe will help neutrals, kind of train up and resolve disputes with us. It's something which is in readiness for the ODR boom that we've all been talking about for the last 4 days and today. And last but not the least, it'll help us do price discovery because that is something which we believe has not happened in this market, and we believe we'll be able to challenge the status quo. What disputes are we excited about? No doubt about financial disputes, which are by far the leader in terms of quantum, and in terms of quantity, and which are easily amenable to a tech-based, tech-assisted negotiation the way we've kind of envisaged it, and also having easier and shorter enforceability cycle. We've talked about COVID, and we're talking about sectoral disputes, which have come into focus, which will come into focus post COVID-19 coming down. And also because the courts have struck down the conflict of interest issues around arbitration by a not so independent arbitrator. And we feel that for us, it's very important to have independence and also believe that the employer-employer disputes at workplace, because today they're independent as one would want to be. And what we attempt to bring to the table in days to come is something called a JustAct trustmark, where a corporate could hand over disputes to us and waive their right to refute the dispute settlement, and that will be credence for them as well. That, in short, is my presentation, and I'm happy to take questions if there are any. I can't hear you, Ketan.
Sorry. I think people are still getting used to Slido, so I'm just going to give it a couple of minutes and maybe I can ask a question of my own in the meantime. It sounds like a great platform. Can you tell us what stage you're at? And the second I'm curious about is for the game theory aspect of it and the AI bit, which we also covered in Colin's presentation. How are you accounting for bias that creeps into any algorithm in that?
So the way we've kind of been, so there are two questions that you asked, but I'll take the algorithm part first. And we've kind of looked at 5 different algorithms. We kind of narrowing it down further. But the attempt is to match each algorithm to the type of dispute as we begin to solve. And over a period of time, understand which algorithm is suited to which kind of dispute. And that, in effect, is also, Kirtana, the answer, because as we use data and as we look at dispute resolution, the success percentage will actually tell us if there is a bias that exists and how much of it gets, kind of decluttered over a period of time. That I think is something where we kind of are keen, and we've got a behemoth of data scientists where product cycle is concerned. We're kind of developing the MVP. Should be there in about 4 to 6 weeks, not more than that. And so we're looking at end of May, beginning of June to kind of start solving disputes and be on the market.
Thank you. Thank you, Prashant. We'll come back to taking more questions if we have time in the end before we move to the second part. I'm now going to bring on Vishwam for his platform Webnyay. Vishwam is a lawyer from India, but currently in the disputes team in Dubai. And he's taken his interest to also build an ODR platform and is working on it. So yeah, Vishwam, are you here?
Thank you, Kirtana, Sachin, and Agami. Can you see my screen?
Yes, it's starting to share. Yes.
Perfect. So basically, our ODR platform is called Webnyay. It's basically an integration of two words, web, so the World Wide Web, and nyay, which means justice. I think that's how we came up with Webnyay. Quickly moving on to the team. So we've got about 5 people working right now. So I do sort of international arbitration pretty much every day as my bread and butter. So I've got over 7 years of experience. And Karan, who's also on this call, is a software developer full stack. He's also got 7 years experience and he's worked with a lot of startups, leading startups and companies in India. So together with a couple of other people, we've been sort of building up on the platform. Essentially, I think what we're focusing on is to begin with arbitration. So I think our platform will have both online arbitration and online mediation, but our focus once is arbitration, primarily because I think generally people don't come up to disputes as this. So if you have a problem, if there's like an e-commerce problem you have with Flipkart or say with Ola or with Uber, you would approach them first and you would try and negotiate it before. And if that doesn't work out, only then people generally want to go into like, go to consumer court or go into the banking ombudsman or arbitration. So I think initially our approach is to initially go for arbitration, but then also give everybody the option of mediation. Or obviously there can be, a mix of sort of mediation, arbitration, etc. So I think that's what our focus is. We're working on automating various stages. So in all stages of an arbitration. So starting with filing a request for arbitration, the answer, or then your pleadings, etc. So we're automating all of that. So basically, you just have to if a person has a dispute, he wouldn't need a lawyer to begin with. He can just answer a very few simple steps, very few simple questions, go through simple steps, and that would automatically produce pleadings in the way you would actually have in an arbitration. So it wouldn't be very different from how you would go about if it was an ad hoc arbitration or an MCI or a SIAC arbitration, etc. So we're adopting a very sort of standard procedure of international or domestic arbitration that you would see for any disputes. Generally, they're obviously followed for bigger disputes, not for smaller disputes. But our model is basically to make that complicated arbitration, which works for complex and high value disputes, to work very simply for small disputes, which are low value but high volume, like we've been discussing. Our focus is also on multi-party disputes. So we believe if ODR has to succeed, it has to sort of take into account that there will be multiple parties in a dispute. For instance, if you look at the marketplace model for Amazon and Flipkart, there's not only a dispute between the consumer and Flipkart, but also often between Flipkart and the actual company who's selling it. So the seller, the Flipkart, which is the sort of marketplace model, and the consumer. In construction disputes, I mean, construction is probably an odd example to discuss, but there are often disputes between employer, contractor, and subcontractor, etc. So I think we're building a platform which takes into
2-minute time
Can
check.
you hear me?
Yeah, 2-minute time.
Thank you.
Yeah.
Okay, thank you. So we're building a platform basically for multi-party disputes. Our initial target is e-commerce and finance, and I'll come on to my next slide, which deals with the tech side. We're not going to focus on capacity building to begin with, because what we're doing is we want to already focus on the expertise which is there in the market. So we don't plan to go about training arbitrators, etc. What we do plan to do is once we have a dispute, we'll allocate it to an arbitrator and then sort of induct them into how to go about it from an online perspective. So we plan to reach out to a lot of former consumer court judges, etc., and people who are already experts within the finance field or the e-commerce field, and we sort of have an internal database of these people who are willing to work with us. Artificial intelligence confidentiality, so we're building those into our platform. So the purpose of time, I'll move to my next slide. So where we are currently, we've got the arbitration flow ready. We're working on sort of VC integration, so you can video conference with people in an arbitration and have online hearings. We also have the capability of doing on-premise stack and on-cloud deployment. So the way this would work for confidentiality reasons is that the data will never leave the data center. So we're working with, say, Yes Bank or SBI. Their data or their contracts will always be in their data center, and then we would have sort of API integration with them. So there's no sort of movement of confidential data from their data center to other centers. And once our MVP is ready in a few weeks, months' time, we've got a fintech company who's willing to test the MVP with us for them. So we'll be dealing in a lot of blockchain and smart contracts. So I think that's what initially we want to start with. But like I mentioned before, our target is both e-commerce and fintech and finance companies to begin with. Obviously, then we would branch out across sectors and industries. So we're looking to partner with sort of ADR practitioners, arbitrators, mediators, conciliators, neutrals. And we're also looking to partner with more businesses and enterprises who sort of are looking to get into the ODR space. Thank you.
Thank you, Vishwam. I'm just quickly looking at Slido. What is your comparative advantage compared to other online arbitration solutions? Is it the tech, data, or the team? We have Munim from Slido asking.
I think it's got to be a mixture of both, Kirtana. I think any company to begin with, it's all about what team you have and how much quality you give. So it'll be a bit of platform, bit of expertise, and I guess a lot of it will depend on how much we can resolve disputes to everyone's satisfaction. So I think if you look at arbitration generally without the online aspects, people have been generally happy with it, which is why it has sort of been around for like hundreds of years now. So I guess one thing which will set us apart is the quality which we will bring upon and the expertise which we are looking to tap into. So we're not looking to train arbitrators from scratch and say, come solve this fintech dispute worth like 5 lakhs or 10 lakhs. We're looking at people who've already been consumer court judges, who've already been banking ombudsmen. So they completely understand the sector. What they just need to understand is how to get it online and how to resolve disputes online compared to when they were doing it in a consumer court or say in a banking ombudsman office, etc.
Sounds good. I think only because we are short on time, I'm going to move to the next innovator showcase, which is Harish Narsappa from ADReS Now. I think people who know Harish knows that he knows many caps. He's a lawyer. He also has a research and policy organization, and now they've started ADReS Now to resolve disputes online. Harish, the floor is yours. Harish, you're on mute.
Mute.
Yeah.
I think it's fine now. Thank you, Kirtana, and the Agami team for organizing the ODR week and giving us an opportunity to be making an introduction to ADReS Now today. Let me share the PPT. Okay. It should come up now. Yep. Okay, so I'll jump straight into it. ADReS Now was conceived about a year ago, and we believe we understand the problem that we are trying to solve. We don't believe this is merely a technology problem. We believe this is a people problem and a process problem. And we believe we understand the problem, the various facets of the problem that is dispute resolution. And we have worked hard to come up with a solution based on various factors. Now, the team is key, as some of the other presenters also mentioned. The team that we have at ADReS Now is very experienced, not just in technology and law, but also in understanding the dispute resolution process, whether it's the judiciary or the courts. Both Kishore and I, we are founders of Daksh, and we have studied the judiciary in India and all the attendant problems in detail over the last 10 years. So that gives us a significant insight into the processes that really need to be in place to run an effective dispute resolution platform, whether it's online or offline. So, and the reason I say this is without these processes, it doesn't matter which medium you use to resolve a dispute. Online is just a medium, and we believe that's the way to go forward, which is why ADReS Now has been set up. To complement the knowledge that we have in terms of the processes, we also have a good tech team. We have a very experienced CTO, Keshava, and Kishore himself is an experienced tech guy. We also have Karthik, who is a lawyer with experience of more than 20 years and advises on many issues and relating to startups. And he is very well networked with the arbitration community. Our CEO is Bhargavi, who is also on this call. She's a lawyer in the BFSI space, has worked in New York and India for many years, and has also worked on many developmental challenges in emerging economies. So let me go straight to the platform. Where are we on the platform? To preempt the question, the platform is ready as far as arbitration is concerned. And for mediation and conciliation, we'll have those two modules ready by June. We are looking at solving disputes of varying complexities. We're not focusing on any particular sector, whether it's e-commerce or tech or fintech or NBFC financial disputes. We have been fortunate that we are actually running three broad categories of disputes on the arbitration platform in different sectors. I can't talk more about it, unfortunately, because there are a lot of confidentiality issues with the people with whom we are trying the pilots currently. But our goal is to see disputes go from beginning to end and not just being resolved either through conciliation or mediation. It's good for the disputants if the dispute is resolved through mediation, but for an arbitration platform to be tested, for the entire process to be tested, we are looking to run the process fully from end to end. The platform itself is very intuitive in terms of accessibility to people with differing technical skills. While yes, arbitration has significantly been used until now by large corporations or businesses, we're also hoping to roll this out to disputes which have individuals as disputants. And that is where the need to create an intuitive platform and not a complicated platform. We have got extremely good reviews for our platform from the clients who are using it in terms of its ability to be understood easily and to use.
Harish, quick time check, 1 minute, okay?
Oh, 1 more minute? Okay, okay. In terms of, I talked about process earlier. We have a unique proprietary process management tool that's built into our platform, which is what will ensure that the dispute sees resolution very quickly. We have an API-first approach, which other people have talked as well. We want to solve disputes anytime, everywhere, all the time. Solving at scale is the key, and that is where ODR should play a significant role, and moving online is a significant thing. Transparency, trust, AI tools, people have talked about it, I won't repeat it. These are all tools that are available to many people. It requires knowledge and how to use it. That's what we bring to the table. Thank you.
Thank you, Harish. We have Mr. or Ms. Ashoka Pati asking on Slido, will your platform adapt for other institutional arbitration rules? What is the process, I think they're asking. You're on mute, Harish. Harish, you're on mute. Somebody. Varun, can you help me unmute?
Okay. So yes, the platform can be used with the ADReS rules, ADReS Now rules, as well as with other institutional rules. The platform is amenable to use, but it can't be used in a modular fashion. You can't just say, I will just use a video conferencing, or I will just use the transcription service. We believe that the good solution is where the entire platform is used, but you can use it with other institutions.
Okay, I'm just going to quickly check. Will the challenges of expensive arbitration carry forward into ODR arbitration? Asked Munim on Slido.
My answer is no. If you look at traditional arbitration, about 50% of the costs come from heads other than the arbitrator's costs and the lawyer's costs. We believe there can be an immediate reduction of about 50% if arbitration moves online. Lawyers' costs and arbitrators' costs, depending on the complexity of the dispute, obviously will be there, but I think the other costs associated with arbitration should disappear immediately.
Okay. Thank you, Harish. I think we are already a couple of minutes past time, so we can now move to the second bit of it, the open house. Thank you so much to all our innovators who showcased their products at early stage. It is really exciting to see where all the products will take us in the ODR market in India in a couple of years. It's really exciting. We now move to open house, which is, can I request everyone to mute themselves, please? Everybody
Yeah.
mute yourself.
Folks, please mute yourselves if you're not. Yeah, back to you, Kitana.
Perfect. Varun, can you help me mute wherever it's not being muted? Thank you. Thank you. So we are now going to move to open house. Here, honestly, we've had so many interesting topics and ideas come up over the last 5 days. We put out a poll to all the participants, and we've chosen 3 topics that stood out the most: e-signing, enforceability, and mandating ODR. Prathamesh Popat will be moderating this session, and we have one designated responder for each of the issue, after which it is open to all the participants on WebEx and on YouTube. So please post your comments on Slido, and we will also open the floor up here for other people to share their comments. Prathamesh, the floor is yours now.
If I can just say one thing, Prathamesh Popat is one of the people who's been espousing the ODR, kind of vision for so long, almost 20 years, and integrally involved in the development of this field, involved in the autonomy community. So it's wonderful to have him here. Just a request that all those who are designated responders for these issues, just please be ready to unmute and kick conversation off. You know who you are. So hopefully this conversation should go from you into a broader group discussion, but we need to start with you. So, Prathamesh, over to you. If you're not speaking for the 1,000th time, please mute yourselves. Thank you. Rukmani, sorry, but I can see that Rukmani, please mute yourself. Prathamesh ji, over to you. Now, I'm only hoping that Rukmani was not
I'm just checking.
Prathamesh, are you there?
Prathamesh was here at the beginning. Just saying
Prathamesh is not here. Hi, in case Prathamesh is not here, we can just kick off and start the conversation. Once he's there, we can hand over back to him. So, yeah. So maybe we can make him do that. Is that okay, Arun and Kirtana? We start off and then bring in Prathamesh as and when he logs back in.
So I'm just trying to get him on.
No worries, no stress. So let me just kick off. I mean, because I think the most important thing is to use this time. You use this time for the open house. Let me kick off. The first issue that has been coming up again and again is this issue around e-signing. And the issue that has come up is that, is e-signing going to force the ODR process? Is it going to twist the ODR process? Because at the end of the day, unless you integrate an e-signing component into it, the settlement agreements, the awards, those things, are going to be problematic, right? So no ODR system can really exist unless it's as digital as possible, and it doesn't break down in terms of the need to suddenly go offline for something significant. So this question has been coming up, and we've pulled in the co-founder of probably the most promising startup in this area in the country, also a member of the Agami community. Wonderful to have Shivam Singla. Shivam, do you want to take a quick crack at this issue of e-signing and just sort of kick off the conversation?
Yeah, thank you, Sachin, for introducing me. So I completely agree with you So when you say that an ODR platform without e-signing is something which is probably even hard to run at scale, right? Because like the one of the core value propositions of ODR is to ease the mechanics of the dispute resolution process. And throughout the legal industry, paper is something which has been the one of the biggest cause for adding to the mechanics of the process, right? And so is the case in dispute resolution as well. And given that in an ODR platform, there are three elements in which three.
And now I'm back, but that's crackling, crackling. Right? It came for a moment, now again it's.
Yeah. So the way I see it, there are three elements in.
That is my side.
So there are three parts in the ODR process where I feel that e-signing becomes very relevant. One is obviously the underlying contracts or the documents based on which the dispute is happening. Second is the filing aspect of the filing documents. And third is the awards and the concluding documents, right? And unless we digitize, remove the paper out of this process, the process isn't likely is it's.
Sorry, Shivam, just repeat the last 30 seconds of that. I think we might have just missed it because Prathamesh is getting on. Can you repeat the last 30 seconds, please?
Yeah. So what I'm saying is there are three parts to the ODR process where e-signing becomes relevant. One is the underlying document or the contract based on which the dispute is happening. Second is the filings, and the third part is the concluding documents or the awards. Right? And unless the way we are envisaging how ODR will automate all the microprocesses, for example, I think in one of the sessions there was a case scenario that came up where I think Pramod was mentioning how he envisages a situation where maybe a borrower can raise a dispute on a platform, and automatically the platform can fetch some documentation or data from the bank's database, and based on that the dispute resolution can be automatically kicked in. Unless the documentation and the documentation of it is automated, it is not possible to ease the process. And from based on what based on my experience over the last 3-4 years in this field, uh, I have realized that the issue, the perception, there is a huge perception issue around e-signing, because of which people, there is that lack of sense, that lack of comfort, right? Because in the legal industry, we are very used to being in our comfort zones because the stakes are so high that like it takes a lot for us to step out of the normal process and like look around, which is, and counterintuitively for digital documentation, it's the IT Act has been there for almost 2 decades, right? And the IT Act has recognized digital documentation, has recognized digital signatures, electronic signatures for decades. And in fact, the government surprisingly has been one of the biggest champion of digital documentation, contrary to what we might contrary to what is usually the case, right? Because like all company filings, MCA filings, GST filings, e-tendering, everything, been the first mover on digital documentation. So I would say that for from an ODR perspective, it makes given that courts so in a court process you still have an excuse, right? Because you still have an excuse that I don't know whether court will accept it or it's not that common right now, so I don't want to use it. But in an ODR process, when you're innovating the around the entire process, and you are going ahead in eliminating the mechanics, like in easing the mechanics, it makes more and more sense to integrate e-signing into every aspect of the documentation of the ODR.
That is super insightful, Shivam. That is really articulated so clearly. Can we take maybe one more comment from the crowd? Anyone who wants I know Prathamesh is back. I'll hand it over to you, Prathamesh, but just maybe take one more comment or insight from the group that's here. Anyone wants to unmute and share their thoughts on the e-signing question? I know that in the finance discussion, there was quite a healthy. Pramod, do you have a take on it? Do you want to share something?
So my own thanks Sachin, and I tend to agree with what was described by Shivam. I think the reality is that both digital success. That's a big
So unfortunately, Pramod, your connection is not so great. May I request you to just drop something into the Slido, I think, or into the chat here? I think we want to play back what you're saying, but the connection isn't so great. Meanwhile, please do continue to share your thoughts on e-signing. We're going to continue this theme, and on the Telegram group as well, we're going to be continuing to discuss this issue around e-signing. I can already see conversation kicking off. Akshata from Sama, has there been serious issues in your personal experience? So that's kicking off. We'll take that offline, maybe onto Telegram. But back to Prathamesh for the remaining two questions. Prathamesh, over to you.
Sachin, I don't know if Prathamesh's connection is still solid enough.
Okay, got it. No worries at all. No worries. So we can just continue with this. Let me pick up on the, please keep the conversation going on the chat on e-signing. It's a real significant issue. I know from entrepreneurs who have said we need to look at this issue. They can't, we need to have a clear position on this issue. And of course, we need tools to be integrated so that, we have a completely digital process. It shouldn't break. So this is a critical issue. And I hope this conversation goes on in the chat and possibly in the Telegram group later. We can also continue it in other forums. Thank you, meanwhile, Shivam, for sharing your very practical, solution-oriented take on this. Let me just move on to the second question. And I want to bring this, this question has been popping up this week as well a few times. And this has been around the, the legal framework for ODR. And it's kind of a question that has come up saying, does ODR require a legislation? Like, is there legal backing for ODR? And I think for a lot of ODR practitioners, it is a sensitive topic. It's like gives you the heebie-jeebies. Like if somebody says, we need additional legal sanction for ODR. But I think it's important to bring this issue up and to ask people who have the take, who have the perspective on this. I want to ask this question to Shreyas Jaisimha. Shreyas, can you share your take on, what is the legal framework on ODR? Do we need another legislation? Should there be questions? Over to you.
Thank you, Sachin. I hope I'm audible.
Very clear, very clear.
Thank you. I wanted to say that the question of enforcement is of the ODR process. We are talking here about enforcement of a conciliation agreement or a process for enforcement of the arbitral award. Both of those are governed by the Arbitration Conciliation Act insofar as India is concerned. And obviously, it is good practice. And I think later on today, you will come up with some model ODR clauses, which we've been discussing. But if the clauses have been drafted specifying the seat of arbitration, otherwise conforming to the contents that Section 7 of the Act requires to form an arbitral agreement, I think there's already sufficient case law to determine that the arbitral agreement itself can be concluded electronically. It does not require to be written in a way that is on paper alone. Even an exchange of emails is fine. It should be in writing, but writing can be interpreted to mean an exchange of electronic correspondence. But the challenge from lawyers in trenches can come from any angle, can come on the transparency of the process. And there's a lot of fear that comes from uncertainty and intransparency. So I think platforms that are in the ODR space are who are able to transparently explain how the confidentiality has been maintained, how the neutrality of the arbitrator has been identified and preserved, would stand a better chance when it comes to the enforceability of their decisions. Internationally as well, there are different approaches taken. Insofar as the UNCITRAL is concerned, which is the body of the United Nations dealing with harmonization of trade laws across the world, there are in fact suggestions as to what ODR platforms should take. What we have heard from the startup community already is such a plethora of technical tools that are being developed. I think insofar as the view from the courts who are concerned with enforceability is concerned, they would want at some stage to see standardization of protocols. And so maybe the time will soon come when ODR players will soon recognize the collective wisdom in creating technical protocols and enunciating them. There are final issues that are expressed on the stamping of awards. And this is a frequent question that has come to us when we talk about enforceability of awards and the timing in which they have to be stamped. But I will say that these are all issues which will work themselves out in over time, and it should not hamper and hinder the spirit of enthusiasm and entrepreneurship that has now been unleashed in the ODR space. But some more attention to standardization of protocols will assist everybody in the long run. With that, I will end my comment.
That is super clear. Thank you, Shreyas. That was clear. And yesterday's conversation where ODR for law firms also brought to light some of these points. I would encourage any other comments or anybody wants to reflect on this point of enforceability and a legal framework for ODR. Is there someone here who'd like to? And the best way to do it is you mention this in the chat and I can then call you. Otherwise, it'll be one of those chaos with unmuting. So if possible, if you can mention in the chat if someone wants to just weigh in on this enforceability thing. Yeah, we can see some comments coming in now. We can see, in fact, I'd like to bring a question back out. Why not? You know, Vikram asked this question saying, since unilateral clauses are struck down, can institutions use an independent institution to appoint or conduct ODR proceedings under the old clause? Will it be a ground for challenge? Vikas, you want to speak on this question?
Yes, partly because I've written something on it, and that question's probably stemming from there. The unilateral appointment clause question is a vexed one because I think the Supreme Court's gotten it wrong from a very jurisprudential point of view, because they've extended the requirement of independence and impartiality to the appointing authority, whereas the Act only requires that of the actual arbitrator. But in any case, given the law, it is what it is. The current position is that even if a clause says that a institution can make an appointment unilaterally of an arbitrator, no one within that institution can make it because everyone within the institution is presumed to have some sort of an interest in the outcome of the dispute. If that was delegated to an independent institution who has no outcome in the outcome of the dispute, who has no interest in the outcome of the dispute, I don't see how that that independence requirement would be breached. And to that extent, appointing an independent institution for existing clauses to make that appointment, in my view, is acceptable. The only problem is that the Supreme Court, while making this finding, has used extremely broad wording, to the sense it says that no person within the institution can play any part in the appointment process. Now, if you use that very broadly, then even the process of selecting an independent institution to make that appointment is participation in the process. But I think we need to take a slightly more pragmatic view, because about 60 to 70% of the contracts in India, especially if you take government contracts, especially if you take bank contracts, are these unilateral appointment clauses, and historically they've been held to be valid by both the Supreme Court and the High Courts. So to sort of reconcile those two, I think the only way out is to say independent arbitration institutions can make that appointment so long as they have no interest in the outcome of the dispute using existing clauses.
Thank you very much. And this is a conversation that I think, again, lends itself really well to a continued discussion in the community. Those of you who are not from a legal background, don't be unnecessarily alarmed by this issue. But the fact of the matter is that when we are looking at a solution like ODR, we're looking at bringing together all the components. The legal understanding needs to be solid. The technical pieces need to be solid. All of the design pieces need to be solid. So I think it's absolutely important that we recognize that we require specificity and clarity at every level, and these kind of issues could end up derailing the process if we're not clear about them. That's the reason why we need to discuss these issues. I want to take the last question. I know Prathamesh ji is there. Prathamesh, what I'm going to do is I'm going to ask you this question as a participant as well. So I'm going to ask Renuka this question, this last question, but I'm going to ask you Prathamesh ji also as a participant, because we don't want to lose your voice, unfortunately, thanks to the internet connection. So I will ask you this as a participant. But before that, let me ask my last question around the last issue that folks have been talking about. What is the viewpoint of people on making some dispute categories mandatorily first ODR, where you require that they first attempt ODR and then are moved on to other forum? What is your viewpoint on that? And are there categories you feel lend themselves to this? Is this a positive thing? I'd like to bring this question to Renuka Sane from NIPFP, who's been kind enough to join us today.
Thank you, Sachin, and thank you everyone for having me here. I think that when you say mandatory, the bell that rings in my head is whether it should be mandatory by government or by law. And at that, I would say that it is always, very dangerous to make things mandatory. Some of the most important shifts from offline to online have happened because the online systems have been so good. And if the shift in ODR is not happening, then we need to ask ourselves, what are the pain points why this shift is not happening? And I think the preceding discussion in the last 15 minutes on e-signing and enforceability are examples of what might be holding the shift to ODR. And I think those are the pain points that we need to focus on solving, because once you start making things mandatory from a government or a legal point of view, then you also run the risk that you're going to miss out on all sorts of innovations that we are not anticipating today, because we have kind of mandated something based on what we understand today. So I feel that there is always, there might be people who are unwilling to shift today. And there's always a price at which that shift starts to look reasonable and starts to look attractive. And we need to understand what that point is and what are the pain points why that shift is not happening. And to some extent, I would say, given the many ODR platforms that we have seen, the shift has already started to happen without any mandates. And if over time we can learn through the experiences of all these platforms and many other pain points will emerge, then it gives us the flexibility to solve the real problem, as opposed to, getting everyone on this platform by just mandating it and therefore ignoring the root cause of the problem. So in terms of the companies like banks or other financial service providers making it mandatory for their customers, I think, yeah, sure. I mean, that's a private contract between two parties. And if one party wants to say that, you know what, I'm only going to do collections, or I'm going to solve your grievances online first, then I think that is absolutely a private decision and different companies can choose differently.
That is a very wise answer, Renuka. Thank you very much for sharing that perspective. Let me bring in Prathamesh ji. Prathamesh, what's your viewpoint on this? Can you add to this?
In my view, the very use of the word mandatory sometimes puts people off. And at the same time, if you weave it into the system, where I don't know whether people have been watching the Big Bang Theory, where Sheldon is told that, well, that's part of the system. And then he says, okay, well, if that's how it is, that's how it is. So if you specifically say that, no, I want you to do this now, people may not be so up for it. But if you say that's part of the system, you know that's part of the system. There's a different system in buying a ticket in the bus where you get in and buy it, and there's another system at the station, railway station, where you buy the ticket first and then get it. So everywhere, if you have a system in place where you just put it there without using the word mandatory, people don't mind it. I find even mediations coming from the court, when the court has not been kind enough to explain the process to the parties and cajole them and just say that I am referring to mediation, then they are not so up for it, and it takes a lot of time to get them on board. So in my view, mandatory, yes, it must be, only because people have not had a taste of it. In my young days, I used to have Italy with sauce, ketchup. It was not mandatory, but I was cajoled to try sambar, and now I never touch ketchup when I have my idli. So it's something like that. You can't make it mandatory, making it sound so, and yet you have to make it part of the system that people just accept it as a way of life.
That's so well said. And Prathamesh can always be counted on to give hardcore real life analogies that make it all very real. But, I just also want to point out that we've been having a nice, robust conversation on the chat where people are now starting to really weigh in on this subject. And one thing you realize about this mandatory thing is that, why, like, we can't have a black or white. There are like examples, like for instance, Tara mentioned that there are voluntary opt-out models where you actually make something mandatory, and then they have a voluntary opt-out model. So there are good examples. We should be flexible enough to look at what has been done all over, and also on this e-signing thing, there's a lot of discussion. In case you're not following the chat, I think people are saying that we need to look at an integrated solution. So e-sign is absolutely essential. Please do follow the discussion that is happening. People have weighed in on different dimensions of it. Thank you very much. I'll just stop for a second before we move to the next component, the last piece, which I'm super excited about. Any other viewpoints that people want to share, something you've been holding on either of these three things that you feel really needs to be reflected back? Please do. If your internet connection is good, please send it to me in chat. I'll call you out and let's get your voice in. Anyone else? I'll do an auction going. 1, 2, 3, gone. Okay. No other questions, all on chat or on Slido. That's fantastic. Okay, before we move on to the last component, and this is a piece that is so important to ODR Week, and I just want to stop here and say, ODR is not a fancy, this is cool, this is technology. It's a necessary component of our national success story, a national kind of social, economic, and citizen systems thrive. That is how vital it is. So, this, as we walk into this last component and then walk out back into our lives, all of us have to be champions of ODR. So I do have a request to everyone that there are 3 things that everyone who's dialed in this week, followed this week, should look at. You don't have to do all 3. If you do all 3, that's great. And I call them, and all the people who hate this sort of strategy are going to, send me bad messages. But the 3 C's, I'm going to call it the 3 C's. Please bear with me. The 3 C's, and you can pick which C's or all the C's. C number 1, clauses. We have open clauses that Shreyas and his team and a few other people have weighed in, have created a open Google Doc of clauses that you can take and adopt for any combination of ODR, right? With a little guidance note on how you can do it. So we'll be sharing that. Open clauses, you can adopt them for your contracts. You can even come back with queries on how would I adapt this, let that be open, let that be known. So embrace an ODR clause. That's the first step. We're going to be sharing this anthology of clauses that you can adopt for various combinations of ODR for your contracts. Even if you're a freelancer and you want to be liberated from a stupid statement like the courts of this will be addressing my dispute, and you're not going to go there, you can't do anything, put in a clause that actually helps you at least discuss it or get an arbitral result of it, right? So the clauses, that's the first C. The second C is campaign. And the campaign piece is that you can see there are so many misunderstandings of ODR. Some people think it's the application of technology to courts. Some people think it's the application of technology to their existing mechanisms of work. Maybe it's a combination of all these. But I think that this week has been a greater understanding of what ODR is and how it can work, and why it's not just some fetish, it's a reality and necessity. Can you campaign for ODR where you are? And this is not to embrace a certain solution as it is, but to become a co-creator in that process. So do campaign wherever you are, inside the law firm environment, inside a business environment, inside a practice area. Please, the second one is campaign. Third is community. It's absolutely vital that we engage, we work with each other, we learn from each other, and we move this forward. And there is a Telegram group. There's a to that group that will be shared here. Do join that group and participate in a level of alignment, a level of, it's not to say everyone's interests always align. The best part, the best example I give about the Telegram group is a whole bunch of startups that are competing against each other are there. And they end up sharing resources, talking to each other. If they can do this, then all of us can do this. People here in the last week have been floored, have shared meticulous details of their product. I mean, I just want to say that they shared meticulous details of their products. They have just come and said, here is our learnings, here is our solution. Hats off to them. That's the way we have to move forward on how this has to happen. So the 3 C's, clause, campaign, community. We will be sharing that out, but these are the ways in which you can make a difference. I am now going to move to this piece that I'm excited by. And we want to end strong. We want to end with the question, where do we go from here? So we have a circle of people. We have, and I'll maybe a quick hand raise from the folks. Chittu's here. Awesome. Pramod is there. Great, Pramod is there. I can see. Rajesh is there. Fantastic. Shwetasree is there. Fantastic. Awesome. So we have a little kind of circle that we want to ask very simple, but hopefully searching questions too. So let me kick off by bringing this question, bringing the first question, which is, what is the one thing that you think that business can do or should do to accelerate ODR? And I'm going to pick 2 people to ask this question to. I'm going to ask this question to Pramod, and I'm going to ask this question to. So let me start off with Pramod. Pramod, what is the one thing that business can do to accelerate ODR in the country?
I think just by embracing, I hope I'm audible now. I apologize. The previous time was, I think, poor show.
Great.
But very quick. Yeah. So I think businesses indeed, by both looking at the advantages of direct connect at some level with the consumers that they service, will really benefit quite a lot. I keep emphasizing that whoever embraces ODR will actually be enabling a two-way street. It can't be thought of as just one type of dispute going into the ODR platform. If the consumers have issues and disputes, you have a wonderful opportunity of directly engaging and solving for those. And so to me, experiment, when we started looking around, Sachin, you would know that we ended up having to run a challenge to actually find people who would raise their hands. And lo and behold, we are into this entire week where we have almost come across 8 or 10 players who are in quite a different level of sophistication. So there is a lot of choice, and I would just tell the businesses, start experimenting. There is one example, if you will permit me to, sort of cite, which has been part inspiration. It is really HUL, Hindustan Unilever. And the way they address their disputes with distributors was really to offer a conciliation panel. And they told the distributors that, whenever we have disputes, this conciliation panel can sort of address the issues. And one of the trust components which they offered was to say that if this panel decides against HUL, we will not go and contest it, we will not appeal it. And to me, that won a lot of trust and sign up from these distributors. So again, you need not confine yourself to thinking, I want to, what should I do vis-a-vis the end consumer? You have a supply chain, you have suppliers and distributors. You could even engage with them through the ODR platform as a solution for not breaking permanently your relationship because of this.
Thank you so much, Pramod. That is extremely practical and insightful. Let me bring that question over to Chittu. Chittu, what can business do? One thing.
Yeah, so I think, and when I talk about businesses, I'm going to talk about the industries. as well as I think a lot of professionals like ADR professionals as well as lawyers now. They also run a
We
business.
have a very specific question for the lawyers, so I'll come to that later. You can just focus on the business.
Yes, but when I'm talking about business, I think what they have to do is they have to make the shift. Please do not resist. I think people are afraid of technology. Technology is no longer a barrier now. We've seen that at the present moment. So as Pramod said, embrace it, and I feel that everybody should just take it into it. We've jumped into many things right now, so I think they should jump into online dispute resolution. And Pramod has done it. And we need more champions like that who can just come into it and do it without actually being fearful of it. And ODR is not alien, and it's not something we need to be afraid of. So don't resist it. Please move on to it, and please embrace it.
Thank you. And there is so much experience in that just do it thing, because that's the way innovation works, right? You do it. Even if it's like Natasha yesterday said, even if it's got chinks in it, go out there, figure it out. Let me move to the next question, and I want to bring this to Shwetasree and to Rajesh. Or let me just let me focus this question on Shwetasree. Shwetasree, my question is, what can practitioners do? The world of lawyers and all the attendant functions. What can they do to accelerate ODR in the country?
I think then it sort of comes back to the first question of accepting it as a community. And I talked about it yesterday as well, to say that one of the first steps is, look, are you going to actually address it only when it's right on your shoulder? Or are you going to actually equip yourself and equip your teams for it? So, for example, if you're trying to find, and I think it's going to increase even more after the whole COVID situation, is that clients are expecting you to be allies as far as the business is concerned. No longer just giving legal opinions and offering up solutions in silos. You're trying to be a stakeholder in their business and tell them what is it that makes the most commercial sense for them. And if you ask me, a lot of what I categorized yesterday as low-hanging fruit for a large corporation, it actually makes a lot of commercial sense to opt for a way to resolve those disputes that is effective and that is quick. So, I mean, at the end of the day, if you embrace it as a lawyer, I think it goes a long way in building your credibility with clients to say, look, I'm not trying to make this whole money-making thing out of every single dispute that alternate meaning resolutions that make sense for the client's business. To be able to segregate disputes into categories is a skill set that, unless you are mentally geared to appreciate ODR as a possibility, you're not going to be able to do that. And the second is obviously to be aware of all the forms of technology that come with it, to understand who service providers are, to know who you're willing to partner with, to be familiar with their platforms, to know, to be able to actually
I think Shweta's connection is
seamlessly. All of that needs a saying that.
I think we may have lost Shwetasree, but I think we got the gist of our answer. Yeah. Thank you, Shwetasree. And I also want to just flag that the recording of yesterday's conversation on law is up on YouTube. It was hugely insightful because it exposed some of these fissures and brought to light some of these questions around, like, what does it really mean to innovate, especially when you have been a lawyer or a practicing lawyer for a period of time. I thought that was hugely insightful. Let me bring the third question which I have, which is around what can entrepreneurs do? And I want to bring this question to Rajesh and then to Chitu. Let me start with Rajesh. Rajesh, what can entrepreneurs do? And really what I want to ask is, maybe at some level, I want to ask, what can they do right in terms of, taking advantage and moving the boundaries of this opportunity forward? So first to you and then to Chitu, what can entrepreneurs do? unmute yourself.
I will limit when we call ADR, I will call it automated dispute resolution. As you know, that's what my passion is. So what they can do is, as you know, I've spoken to a couple of other people yesterday and day before, a couple of startups called me up for some, brainstorming, is that they need to understand which process and which dispute is most amenable. First, understand the process of, let's say, an ATM transaction, end-to-end process. Then see how amenable is that ATM resolution. Can it be, is it to automation? What are the kind of rule engines? And then maybe take it to a partner bank or, kind of setting it up out there. I think I'll stop there. So understanding a deep understanding of processes which are amenable is, I think, one critical thing my learning has been.
Thank you, Rajesh. And before I come to Chitu, I will say that, I had a couple of technologist friends look at some of our conversations from the last 2 days, and very often their flow was, listen to some comment that someone's making and saying, being too polite, technology can do it, no problem. So there was this attitude that ki sab polite ho rahe hain, technologists don't want to bust the bubble, but 90% of the things we're talking about can be done by technology, and everyone is being too polite कि बोलना नहीं है, क्योंकि अगर बोल दिया तो it's like dismissing ADR. But the fact of the matter is, I don't think it's a matter of dismissing ADR. I think there's legitimate cases and dispute categories that will require the human touch. But there's also probably a large number of categories that don't. And if you recognize that, and so I think there's a huge opportunity in fully doing the ADR as technology driven. I think we should not walk away from that. But thank you for calling that out, Rajesh. I think it's very important for the entrepreneurs to hear that. And what about you, Chitu?
For me, I think we are focusing too much on just moving mediation and arbitration online. We should not, right? I think Rajesh made a fantastic point, and we're talking about large-scale disputes. We're talking about, we had an entire section on banking and financial disputes. We should just not be focused on just mediation and arbitration. There's so much which can be done via online dispute resolution, and technology can really innovate many resolutions in amazing ways. My I think advice to startups would be to focus right on a use case, and really when you focus on that use case, and exactly, I think Rajesh mentioned about process, but when you focus on the use case and you're able to get a resolution for that type of a use case, then that's when true ODR comes into place. And we should keep it simple as well. It is extremely important for us not to spread ourselves too thin and to keep it simple. It's great. It'll be very good to see more startups, on the other side, rather than just focusing on this. So keep it simple and focus on use case, and utilize technology more. I think we saw now video conferencing and internet is not going to solve the whole thing.
Thank you for saying that. And I feel that at some level, what happens is that in conversations where 50% are practitioners and lawyers, sometimes technologists hold back on saying something. That's not the community that we are seeking to build. We want to build a community where we can really define the value of each component courageously. So thank you for sharing that. Let me bring the last question before I come to a more personal question. But the last question that I have, which is, what is the one thing that government can do? And this is a loaded one, but I thought let's bring it, and I want to bring it to Pramod and then wrap up with Rajesh. So Pramod, what is the one thing the government can do?
The way I would look at it is that already the government has done what it needs to. There is a Department of Justice which has ended up recognizing a set of ODR institutions. There is a Niti Aayog paper which says that we want to make India the arbitration hub. There is enabling legislation in the Arbitration Act, the amendments which came through. So to me, there is a whole lot of legal framework and endorsement which already exists. Probably, one of our duties is to make sure that this is heard and understood. I think over the last 2-3 days, what one did here is Is this recognized? Can we have a statute backing it, regulation, and so on? To me, I think those can come later. I think right now what we need is innovation to flourish. We need all of the ODR institutions. And I just want to come back to that phrase of institutions in a minute. But really what we want is that we want to bring all of these technological possibilities that even Rajesh just mentioned to fore. I think they have to be visible and being used by people, and then regulation can follow. On institutions, and I think that's the key that the ODR, and somewhere I guess we are guilty of it too. We have used the phrase platform over the last 3-4 days. We need to position them as institutions. And really, we have an excellent mentor in the autonomy group in form of Madhukeshwar. He created MCIA as an institution very much in India. And to me, all of what these ODR institutions are doing is nothing short of that. They are building exactly that. And by positioning themselves, having the protocols that Shreyas mentioned, having institutional rules, all of it gives both the credibility, but equally a measure in their mind to what they are building. I think that is what would be my way of putting it. And hopefully the government will watch this, support this. Government is amongst the bigger litigants in the country. So if they embrace ODR as well, we will have a lot more, going for the institution building, as I said, and solving issues quickly. So I'll pause there, Sachin, and happy to elaborate if you.
Thank you, Pramod. Thank you. Rajesh, what about you?
Actually, Pramod has covered, I would say, everything where the legal framework exists. I would rather say, I mean, that's what all of us want, is test it out, taste it, so to say. And then only the government will take it to scale. So if you allow me to say, it's something which as an industry and a community, we have to find a very simple use case in the government and find the right champion, in a state government or wherever, because as Pramod rightly said, government is the biggest litigant. So I'm sure if we look around, we'll find some good champion in some ministry or some department. And once, some success is seen, then it's a different story. Then it'll be a tipping point.
Shwetasree, yesterday you had mentioned that even domain name dispute resolution in India is also being done through an kind of an ADR or ODR mechanism. Is that true?
So basically, as far as domain name dispute resolution is concerned, Sachin, we have the INDRP, which is constituted by NICSI. So the policy essentially provides for appointment of panelists who are effectively arbitrators. And so there are solo panelists to whom a dispute is referred. The way it's handled is that whenever somebody basically registers a domain name, the contract terms with the domain registrar provide for the fact that any dispute with respect to the domain name would be referred to this sole arbitrator, who will be appointed by under the INDRP policy by NICSI. So practitioners are all, there's a whole list of arbitrators, and they're all practitioners. And then essentially it's an ODR mechanism where you're filing a complaint, you're giving electronic copies, you're filing everything in electronic form. Yes, it's the government, it's NICSI, so they also expect you to go and drop send a hard copy by courier. But having said that, and a little bit of streamlining could have been achieved as far as that is concerned, and everything should ideally, there's no reason to give a follow-up hard copy. But everything else is done electronically. There is no hearing that happens. So whatever evidence you have to file, everything is electronic. And after that, the panelist essentially decides the dispute. And then, if there is an appeal, whatever, if anyone is unhappy with the dispute, then you're filing a Section 34 petition in the court to challenge it.
Got it. And I think where I was going is, what are these use cases? And of course, in particular, government use cases that we can hang our hat on. What are the ones that we can say, here it's being done, this is how it's being done, how can we go to scale? Rather than fighting this new battle to say, ye nayi cheez hai, aisa hoga, waise hoga, ho raha hai. So
if you think about it, Sachin.
Yep. Shway, you were just completing something. Just complete. I'll come to you, Pramod.
Yeah, I was only saying that the other example that I gave you yesterday was with respect to e-commerce platforms as well. That's another great opportunity. If you're registering as a seller on an e-commerce platform, all it needs is for the platform to introduce a clause to say that ODR will be adopted for any dispute in relation to your listing on the e-commerce platform. And there are so many. We know that in the IP space, we're constantly doing takedowns and stuff like that with e-commerce platforms to say that particular product is counterfeit or whatever. There's a very small percentage of that which goes into dispute territory. The point is that kind of stuff can easily be handled. I see huge potential that way in terms of taking a lot of those e-commerce disputes into the ODR space.
Pramod, you were saying?
So I was about to add that, one of the areas where really ODR could be tested and at scale is really the personal bankruptcy, which is part of the IBC, yet to be rolled out, and which will touch a host of people from across the country. It does require statutory amendment because right now what's envisaged is the DRTs taking it on. But it's also a portion that has not got notified because the DRTs are already inundated with various matters from the banking system. So to me, if the government thinks about it, they could actually refashion personal bankruptcy being tackled through an ODR platform. It can remain private, intimate, obviously involving the creditors and the person applying for bankruptcy and the individual. But truly, that would be a scaling issue, which and it is new. So it is really not disturbing any of the existing structures or forums that have already got established.
Sachin, if I can just
Rajesh,
come in for a
yeah, Rajesh.
I just wanted to say, when you're looking at use case, it just came to my mind. A Motor Vehicles Act disputes are really, a pain for the citizens and a drain on, the judiciary, sort of the lower judiciary.
And it's already an international benchmark. Motor vehicles disputes are already being resolved. So there are these given cases, and absolutely. Thank you for flagging that. So let me just, this conversation on what is suitable is a conversation that can take, that really needs to be gone into, and hopefully there's going to be a dedicated discussion on this. Let me wrap up this session by asking a personal question to each of these four wonderful people. And I will start with, I'll go with Shwetasree first and then go onwards. My question is, so after this experience and this reminder, maybe you didn't need it, of where the opportunity of ODR, personally, what are you going to go do different after this week is over?
I think for me, one of the first things I'm going to do is actually to start the conversations with clients. For a lot of clients, I think irrespective of what we may try to second guess, a lot of clients can find opportunities within their own organizations of taking disputes to ODR. I think one of the first steps is to start those conversations. The moment you start those conversations and identify, because I think what I'm hearing a lot of friends who are GCs in various corporations say is that they've all been tasked with rethinking budgets and rethinking the way they sort of organize their legal structures. And if anything, this is the way to convert a challenge, the healthcare challenge that we're all facing right now, into an opportunity for ODR. So, when everyone is rethinking and wondering how they can save costs, this is a good time to be ambassadors of ODR to start that conversation.
Thank you, Shwetasree. Rajesh, what about you?
So I'll be honest, as far as mind space and time is concerned, I wasn't spending too much time on ODR. I mean, reading up a lot of stuff. After this week, I would say I would evangelize to the government and the regulators specifically.
That's awesome. Thank you, Rajesh.
Well, we've been an early adopter of ODR, so really my ambition is to hopefully see it this calendar year that it is fully up and running and scaled to the size that we are expecting or wanting. We already have scheduled a catch-up call tomorrow, in fact, just to make sure that all of the lessons of this week are absorbed and that we can take things forward. So I'm really hoping that this week has been both a searchlight for all the people watching, especially from the in-house community, to sort of think of embracing ODR if they already aren't doing it.
Awesome. Thank you. And it started with Chitu 20 years back, and it's ending with you again, Chitu. Now, what are you going to do personally? I'm sure it's you'll be like the same thing I do every day, but still, take a shot.
No, Sachin, first of all, thanks to Agami, we've built such a big community, Sachin. And all credit goes to Agami for this community. And I think, what I would like to do is, we are, becoming one of the biggest communities in online dispute resolution. So I want to actually expose this to the world. I really want to have a chapter dedicated in ICODR for India, and have ODR over there. I think that'll be really good. So I will sign up for that.
That sounds awesome. Folks, we are coming to an end of an incredible week. A lot of learnings, including the last minute Zoom kind of shift, government advisory. We'll have more Agami-led conversations, Agami-facilitated conversations. There's an amazing Sunday one coming up on right to internet freedom. Brilliant people in that. So ODR week will be over, but not our efforts to drive hard, action-oriented conversations on the critical issues of our time in law and justice. So, this is not the end, but definitely this is a slight pause as we collect our energies and freshen up for what lies ahead. We are committed to doing our best to get behind the amazing entrepreneurs and leaders that we have who are making ODR happen and make it a reality. It might take time, but really push and make it a reality. I want to just flag a couple of things. One is, remember the 3 C's. There's been a link that is shared in the chat that allows you to pick up these clauses. The Arna Law team and with the help of Vikas from Coder and Pranjal from Sama have prepared this sort of open clauses that we will be sharing, which is awesome. And please do your campaign bit. Please join the community. I'll also say that Trilegal, the law firm Trilegal, has been kind enough to say that once things open up and we can all meet physically, the next autonomy is on them in Delhi. And they will host everyone and make sure that we can do this in a big way in Delhi when we can all get together in person. That's going to be, I don't know when that is, but whenever that is, it feels great. Huge thank you to everyone who was a part of it silently sometimes, even though your work is fantastic. We see you, we know you've done great work, and you may not have been a panelist or a moderator, but we know the work you're doing. You don't need to be, nobody needs to be reminded of that. So thank you for the role you play. Let's continue entrepreneuring. Let's continue innovating. Let's be a little bit, naive occasionally, not overthink it, but at the same time, bring the wisdom in to make sure we don't make basic mistakes. Thank you, everyone. Have a phenomenal week. Any last messages from Keetana and Varun will go in the chat. Meanwhile, have a wonderful weekend, and ODR week is a wrap. Take care. Bye-bye.
Thank you.
Thank you.